Hi class. Alright, so Mr. Palini's outside today. PD day in our school board. Beautiful, beautiful weather. So this video for week 4, it's helpful since I've seen a few of your early submissions on the first factum. Factums are the submissions summarizing the arguments from lawyers in any given court case. And I'm going to go through our template just to clear up some early misunderstandings. You've all done very well for a big new idea like this, new concept, new practice. All of you have missed one or two details, and that's fine. It's part of our learning process. And next few weeks, we're going to do what they do in law schools. There's IRAC and there's CREAC. We'll start with IRAC. It's IRAC. Issue, rules, application, conclusion. It's a template for going through a case study in law school, which then helps you go through real case situations at a law firm when you're making your factums. And it follows a similar progression to a factum. But for this week, we're going to clear up some things about basically what do you keep in this template and what do you replace with new material given the fictional case that you're working with. Whether it's the self-defense case in Toronto, you would actually say it's the City of Toronto court that you're dealing with, or if it's the Humpty Dumpty case, which is basically introducing you to a major form of law, personal injury law, who's at fault if someone gets injured physically. That could be the land of Caroland, or you could make it City of Saugeen Shores, or wherever you happen to live. That's the first thing we're going to look into. Is in the template, the top of the first page will always say which court are you actually giving this factum to. So that changes by case. There's local courts. Most cases are local courts where you have to say it's a court of City of Montreal, City of Calgary, something like that. If the case obviously makes clear that this is already gone through local courts and this is an appeal case, it's then an appeals court of Ontario, Superior Court of Ontario, or Supreme Court of Canada. Could change the province or the other jurisdiction depending on the facts of the case. So the top of the page, you are putting in unique information, okay? And then between, it says respondent/defendant and appellant/plaintiff, okay? So that's where you keep those things in brackets for now, but above that in the space, you give the specific person to show that you identify who is the respondent or the defendant, who is the appellant or the plaintiff. Okay, so it's a defendant if it's a criminal court case and someone is accused of a crime that could lead to criminal charges. You give that person or group, okay, or a few people. It's a respondent if it's a civil case, okay, and they're being accused of any tort that has led to some sort of injury related to a certain type of law, okay. It's a plaintiff if, really in both criminal and civil, it's a plaintiff if you're talking about a person or group that claims to have been wronged and that's why they're going to court. It's an appellant really in appeals cases, and we'll get to that later. In most of the cases we're starting with, you can just go with a plaintiff who is the person or group that's accusing, okay, that, or says that they've been wronged. That's beneath the word and, in the space between and appellant defendant in brackets. Who is the accused? That's where you figure out, is this a defendant in criminal cases or is this a respondent in a civil case? And that's where you will put it in the space before the word and, above appellant respondent, okay? And then when it says appellant's respondent's factum in the middle of that first page, you completely replace the words appellants/respondents, and you just put in, depending on whose side you are arguing as a lawyer, just that person or group's name and factum, okay? Name of law firm, address of law firm, you can be kind of creative with that. You can replace that with name and name, LLP, or some sort of law firm title. And address, you can make up a creative, can be somewhat humorous but appropriate address for this fictional law firm. Okay, names of counsel for the appellant respondent, you replace all of that with basically names of counsel for you say who you're giving the counsel for. It's again a name related to the case. You're not saying appellant or respondent. That's why you got to read the whole case. And after you've said that, beneath that you give your name and telephone, fax, email. You could just, say NA for a case study in a school situation, or make up a clearly fake number, 1-800-685-5555. Okay? That's the first page. Now, second page, trying to get better, here we go, better lighting here. Okay. Second page, statement of the case. All right, most of you got this. This is where you replace any text about this is about the insert a summary of the issue being disputed. That's instructions. You're going to do that. You're trying to boil it down to the shortest, simplest terms. If it is a single issue case, it can be one sentence. You'll notice as these cases develop, there's usually more than one issue being contested in terms of both who is at fault for a situation and how does the law properly apply, both in statutory and in case. And even customary comes up in terms of the idea of reasonable understanding and common sense kind of get claimed in court cases, and that kind of applies to custom, like what do people consider to be normal in this area. Okay, so that's a one-sentence summary. If you can get it to a one-sentence summary, it's great. If you see more than one or two issues, you have like 3 or 4 sentences. Okay, part 2, agreed summary of the facts. Okay, this is where you can keep, the appellant and respondent have provided an agreed statement of facts reproduced here. You could actually put in the names of the people and groups in that fictional case that you're looking at. And then first fact, second fact, third fact. It could be 10 facts. It could be 1 fact. Just what is clear from the reading that you did of what actually happened and what's not being contested. It's the interpretation and who's at fault and how does the law apply, that's being contested. Okay, so it's your own stuff for first fact, second fact, however many facts that you need. Okay? Past legal precedent. You hear different terms and different factums for this, but we're just going to go with past legal precedent to make it pretty straightforward. And yeah, you put a summary of one or more past court cases on the issue. Statutory, like how written laws apply, comes after this, but that should be pretty straightforward. You're filling in blanks and creating your own explanation of past cases. Okay, so the case of could be Khalil versus Canada, I believe is one case that comes up in self-defense law concerning this issue, resulted in a decision of. You explain the decision very concisely with certain principles established. The first relevant principle is, that's where you'd lay out an explanation. You already did it, some of you, for unconscionability when it comes to a major civil case with Uber v. Heller. Okay, some major term that explains how the law applies in this situation that forms precedent in Canada, you explain after summarizing the case. Could be one case that you think is relevant to the current case, could be 5 or 6. That's totally up to you. Okay? And you do have to finish with the name of the case and the paragraph number so other people can quickly reference the information you gave. Okay? It's part 3, grounds of appeal or conviction. Okay, this is where you remove appeal or conviction. If you're looking for a conviction, it means you're working for the plaintiff, whether it is someone who's been wronged in a civil case or whether it's the government in a criminal case. You're trying to get a conviction, you keep conviction if you're on that side. If you're with the defense, you're defending someone, you're a defense lawyer, you're going to make part 3 grounds of appeal. Okay? And some of you kept in our template issue 1, freedom of expression under Charter of Rights, okay, freedom of association under Bill of Rights. Those were just examples. Okay, so just to clarify, it's not like every factum has to appeal to certain subsections of both the Charter and the Bill of Rights. There's some court cases that entirely deal with First Nations treaties, for example. Other cases deal purely with case law. Okay, often Charter and Bill come into effect, but sometimes it's also just the law in a place, like the Ontario Education Act, if there is a dispute regarding schools. Okay? That's where you say issue 1 would be the first piece of statutory law that applies to an issue you laid out in your summary of the issue and facts of the case. All right, so like the issues you lay out in part 1, you should go in the same order for issues you give in part 3. Okay, so issue 1, self-defense for one case you guys are looking at. What applies to self-defense? It's not exactly the charter. It would be statutorily. It's in the Canadian Criminal Code. And there would also then be about the way that the person at that house party used a firearm, brandishing it, kind of threatening with it. How does the Canadian Firearms Act apply to it? Okay, so self-defense, go to Criminal Code. Here's how that, cite the part of the Criminal Code. Could be section 286, I'm not sure, just any section. And then you explain how the law should apply to the situation, okay, with that specific statutory law. Issue 2, it would be, again, for example, for one of your cases, Canadian Firearms Act, section 238 says this. Here's how it applies to brandishing a firearm when you're on your own property and someone won't leave. Okay, something like that. As we say, it's part 3 is sort of statutory. Part 2, cases, is where you look into case law. So for part 2, a good search on any engine, and you should try different engines because they'll bring up, Google, Bing, Yahoo, DuckDuckGo. They'll all bring up different things. Try a few different engines to get better sources. But basically, case law precedent on, then you insert the issue in Canada. You'll find good cases, at least 2 or 3. Then when it comes to part 3, finding the written laws, statutory laws passed by Parliament, or things in constitutional documents like the Charter or the British North America Act. That's where you just type in legal precedent. I find most search engines, if you type up legal precedent on, insert an issue in Canada, you'll get all the written laws. It's harder to find the case law precedent from past court cases. That's why you use legal precedent or just Canadian law on, Ontario law on. You'll find the written laws to fill out part 3 and explain how they apply. For part 2, you got to use case law precedent on in Canada and Ontario to find those past cases. Okay, so it's part 2 and part 3 where majority of what you're writing is you substituting your own research and then your own understanding of the fictional situation you're looking at. How does the past precedents with any past principles, how should they apply? And current laws written, enforced by government, how should they apply? Okay, part 4, additional issues. Don't be afraid, first few factums, to just say we raise no additional issues. This is a more advanced thing where if you have 1 to 4 issues usually of what's being debated, contested as true or false, what actually happened, how does the law apply in your main case that you've already laid out in a short summary, part 1 issues, and then gone into part 2, part 3, part 4. Additional issues is if while you did this, you see something that no one's raised that might change the outcome. If people are debating who is at fault because they were running through a parking lot and shoving each other for a Black Friday sale going into the holiday season, and who's at fault for the shoving, okay, and it turns out that it was an icy day and the department store did not do anything that multiple past cases and current laws say they need to do for keeping an iced and easy to move on parking lot, then that would be an additional issue. Like, actually, if the department store did their job, none of this would happen. So we think that the court should consider a penalty of sorts on a third party. And that would actually change who you think in your first page who the plaintiffs are and who the defendants are. Okay? If that's kind of beyond you right now, you're just kind of getting used to, okay, I got to read a fictional situation. What are the main issues? Okay, once I have the issues summarized, what are past legal precedents? Okay, what are the current laws with explanations for how they apply? If that's enough for you, then when you get to additional issues, you can just keep that sentence, we raise no additional issues. Okay, as we go forward in the course, it could become more marks to see the additional issues. I'll find cases where there obviously are hidden issues for you to raise. Okay, then part 5, order requested. This is where you've already given detailed arguments in terms of what is the issue, how does the past case law apply to it, How do current written government laws apply to it? Okay, you've given detailed arguments in those parts of the factum. Order requested is like a summary. Should be a one-paragraph summary, very concise and easy to understand. It is respectfully requested that the defendant be found guilty or not guilty. And then you say, given a sentence of, if they're guilty. If they're not guilty, just you finish with not guilty. Okay? And you can say that all charges be dropped, as we say here. This is something where you fill it in. Okay? And I say here, if you think that this was a malicious case trying to punish someone who did nothing wrong, you could ask for the side who launched the case to just pay all the legal fees. That's often already automatic in Canadian law, but you could also just ask for additional fees. Okay, so order requested, you quickly summarize what you think should happen. It is respectfully requested you keep that the defendant, you keep that be found. Here's where you choose, guilty or not guilty. Okay, guilty with a penalty of, or not guilty with all charges dropped. Okay, it can really be that simple, because if you've done your job in the factum, it should be pretty straightforward. Why? If there are 3 or 4 issues, you might want to say, this is because past legal precedent and current Canadian law make it clear that either they did something wrong and you explain the wrong that they did, or that they did nothing wrong. That's pretty much how detailed we can start with for order requested. It can become more developed later on, especially as I have different lawyers who work in different subfields, whether it's criminal or real estate law or renters law or labor law. I'm going to have different lawyers review what we're doing here, and we might make order requested more developed later, but as a beginning point, order requested can be 1 sentence to 4 sentences. Guilty, not guilty. If there's more than one issue at stake, the law makes clear that they did something wrong, or the law makes clear they did nothing wrong. And you put some specifics in that make a lot of sense because of what you laid out in past precedents and current laws and how you explained how they apply, and principles, okay? All of which is respectfully submitted by, here's stuff that you fill out, your name, the fake law firm. Doing a digital signature, that's a good idea. You should have a digital signature if you're going to go into college or university, even for various jobs you can go straight into from grade 12. A digital signature, different ways of doing it. You can look it up online, how to make a digital signature. It's good to have. Okay? You could even print this, sign it, and then scan it as a PDF for your submission. Date, it can be the date in the week leading up to when you submit this. Okay, so hopefully that clarifies certain items. If you have any questions, email me. It's basically a title page, all right, where you keep half the template, but you put in fictional names depending on the case that you're analyzing to submit for the assignment. Second page, summarizing the issue, what is being debated, what is being alleged in terms of a lawsuit. All right, past legal precedents, principles from past cases, current laws, how do they apply? Any additional issues if you see them? Order requested, and then your signature at the end, okay? Big thing is just the word issue, meaning what is being debated, contested in the court case, what is being alleged. All right, if you have any questions, email me. Next week we'll go into an IRAC issue breakdown that they use in law school to practice this skill set, and then later on we'll come back to more factums. It's basically for the next little while either an IRAC or a CREAC or a factum to practice our skills with different cases, introducing us to different types of law in Canada. All right, have a good one.